Welcome everyone. In this explainer, we are going to pull back the curtain on the legal system to show you the one concept that is at the absolute heart of every single lawsuit. Let's get right into it. You know, we've all been there, right? Someone breaks a promise, they cause an accident, maybe they damage your property, and what's the first thing that pops into your head? That's it, I'm going to sue them. But can you, really? Is just being wronged enough to get you through the courthouse doors?
Well, here's the thing. The legal system, it doesn't really run on feelings of injustice, you know? To unlock those big courthouse doors, you need something very, very specific. Think of it like a legal key. It's called the right to sue, and if you don't have it, your case is over before it even starts.
And that key, it has an official name, a cause of action. You can think of it like the formal recipe that a court demands you follow. It's the specific, legal claim that proves you have a legitimate reason to be there. Without a valid cause of action, you're pretty much just shouting into the wind.
So what's in this recipe? Well, every single cause of action is built on three essential elements, and you need all three. There are no exceptions. They are duty, breach, and damages. So let's break down exactly what each of those means.
First up is duty. This means you have to be able to show that the person you're suing, the defendant, had some kind of legally recognized obligation or responsibility to you. Now, we're not talking about a moral duty, like being a good friend. This has to be a legal duty that a court can actually enforce.
Second, there has to be a breach. This is basically the what they did wrong part of the story. You have to prove that the defendant, either by doing something or by failing to do something, did not live up to that legal duty they owed you. They broke the rule. Simple as that.
And finally, damages. And this is so important. You must have suffered a real, provable harm because of that breach. We're talking about things you can measure, right? Like medical bills, lost wages, the cost of repairs. It has to be a measurable loss. Because in the eyes of the law, if there's no harm, there's no foul, and there is no lawsuit.
Okay, so theory is great and all, but let's see how this three-part formula actually works out in the real world. We're going to look at two super common examples.
So that first element, duty, it can come from a couple of different places. Sometimes it's created very specifically, like in a contract where two people make very clear promises to each other. But other times, it's more of a general duty that we all have, like the duty to just be careful so we don't hurt other people. That's the foundation of what's called negligence. So let's take a breach of contract case. Imagine you hire a painter. You agree to pay them $5,000 to paint your house. The duty is right there in the contract. They promise to paint, you promise to pay. The breach? That happens when the painter takes your deposit and then just vanishes, never shows up. And the damages? Well, that's the money you lost because they didn't do their job. See? Duty, breach, damages. Check, check, and check.
Okay, now what's really fascinating here is how that same exact formula applies to a completely different kind of situation, like a bicycle accident. The duty, in this case, is that general obligation we all have to be careful and watch where we're going. The breach is the cyclist's carelessness. Maybe they were looking at their phone and hit a pedestrian. And the damages? Well, that's the pedestrian's injuries, their medical bills, the time they lost from work. Same formula, different story.
You know, understanding this three-part formula isn't just for getting a lawsuit started. It is the entire playbook for winning it, whether you're the one doing the suing or the one being sued. And this really shows you the two sides of the coin perfectly. The plaintiff, that's the person suing, they have to prove all three elements, duty, breach, and damages. But the defendant, they only need to disprove one of them. If they can show there was no duty, or that they didn't breach it, or that there were no real damages, the whole case just falls apart.
So you've got your cause of action. You know what you need to prove. But wait, there is one final, absolutely critical rule you have to understand. In the eyes of a court, if it is not in the official record, it didn't happen. Period. Proving your facts isn't just a matter of telling your story. It is a very formal process. You use legal tools like discovery to get evidence from the other side. You have to make objections in court at the right time to keep out improper information. You present your evidence at trial. And maybe most importantly, you have to make sure a court reporter is there, recording every single word.
This quote right here just says it all. So why is the record so important? Because it's the only thing a judge can legally consider when they're making a decision. It's also the only thing an appeals court will ever look at if you lose and you need to appeal. If your best piece of evidence isn't in that transcript, it's like it never even existed.
So here's the crucial takeaway. The legal system isn't just about being right. It's about proving you're right according to the rules.
Understanding your cause of action, that duty, breach, and damages formula, and knowing how to get everything into the official record, those are the keys. If you have a just cause and you follow the process the right way, you can unlock those courthouse doors and get the justice you deserve.